Welcome to the Smart Legacy Podcast, your resource for protecting assets and securing your future. Hosted by Stockton and Kandt, join us as we cover essential estate planning and elder law topics, such as wills, trusts, and Medicaid planning. Stockton and Kandt, your trusted attorney advisors in safeguarding what matters most. All right, welcome to another episode of the Smart Legacy Podcast. I'm your host, Glenn Stockton. I'm managing attorney of the firm Stockton and Kandt, located here in the Kansas City metro area. We have offices in Overland Park as well as Gardner, Kansas, down south. I have in studio with me today my daughter and partner attorney, Sophia Kandt. So, Sophia, welcome.
Thank you.
All right, today we're going to cover the topic of planning for families with young children, because the planning's a little bit different. The risks are a bit different. A lot of people, when we see the majority of people who do the estate planning, they're often older, their kids are grown. Why? Because now we have disposable money to pay for this. I get that. But when we're young, we have young children. Typically, we're younger too. We have young children. There's certainly this risk, and we know the risk is real, that it's there. What happens if something happens to us, whether it's death or incapacity, and we're not able to raise our children? What happens to kids? And it's the number one risk we have, painting with a bit of a broad brush, for when we have our children are young. So we're going to talk about today how that planning is different and things that people need to think about. So, Sophie, I want to tap into some of your experiences here. So you worked for the district attorney's office through the child in need of court as a legal intern when you were in law school.
I did.
And interned in the child in need of court. So maybe share a little bit about what is that court and why were families in that system and what brings them in there? Yeah,
so it's child need of care court. We call it Sync Court, but it's a, why are families in child need of care court? Well, it's if the parents can't care for the children anymore. It may be because of a death of a parent. It may be because incapacitation of a parent. It may be because the parent, for whatever reason, they can't provide proper care for that child. So, I spent a whole year involved there, and I really got to see the impact that being involved in, foster care had on these children and their parents and the families. So it was very eye-opening, and I think it does parlay very well into estate planning and why are we doing what we're doing. And it's not just for the elderly people. Estate planning really is for people who have young families, young children. I've heard you say before, and I think on this podcast, that estate planning is not just about your valuables, but it's also about your values. And I think this is why we're talking about this, because your children, what are you going to do if you're no longer around to be able to provide for them? So, I saw lots of just traumatic things happen to families and children while in child need of care. What happens if mom and dad, children something happens to them, they die, they become incapacitated right away. Children go into foster care. So many times there's not enough foster families available at that time. If they haven't done any planning in advance, they haven't appointed guardians, then they're going in, and sometimes they're sleeping on the floor of the KVC, the office there, because there's cots set up. But, that's happening. Sometimes they can find the foster homes, but if there's multiple children, they don't always get to stay together. They may be split up.
It's one of those that we, if we've got young children, we just have to have a plan. But it goes back to what we have said in earlier podcasts, and we tell people all the time, don't overcomplicate this stuff. Right. Keep it simple. But we understand and recognize this is a hard decision. We're talking about our children and who's going to raise our children. And sometimes mom and dad don't agree, even in the best situation. Who's going to be that person? And we're going to talk about how to help you make that. But what I would encourage people to do is, it's never going to be the perfect decision, right? And we beat ourselves over this. But statistically, most of us, the vast majority of us, are going to outlive our children's minority, meaning we're going to see our children grow up. So we beat ourselves up over this decision that hopefully never, ever comes into play. But because the consequences of not planning for this are so great that we have to make it.
Right.
So
yeah.
we're going to get in because you brought up the term guardian. But before we get into that, I want to just maybe paint a picture a little more. And I think, what you saw in Sync Court, and certainly my involvement that I had as a young attorney through the child in need of court care system, I've seen that, right? It's devastating for families. So scenario where, husband and wife are in a car accident. Often this happens at night. Children are maybe with a babysitter, and the knock on the door is the police and protective services coming in because those children need to be placed somewhere. And they don't have information at that point. They're trying to locate, figure out who is family, locate family. If they can't locate the family, or the family's not in the area, those children are taken into protective custody. As you say, they may end up on cots at KBC. I can think of one example in particular. There were 4 children. The children were placed in foster care. They were able to place 2 of them with one foster parent. The other 2 were moved to, I believe it was down, one was in Parsons, Kansas, one was in Chanute, Kansas. The other 2 were up here in the Kansas City area. They were divided up into foster care.
Imagine that, mom and dad, you've just been told that mom and dad have been in a terrible car accident, and, maybe they're alive, maybe they're not. And now you don't even have your own family, your own siblings.
You've been pulled out of your home, put into foster care, separated from your siblings. These were young children. The oldest were grade school age. Youngest weren't even there yet. And so devastating. And you wonder what the long-term effects of this. But there's so much more that goes in. So as a parent, we have the right, when we do estate planning, to decide who's going to be the guardian of our children, who's going to raise our children. And we get to choose that. And we'll talk about how that's done, but still the court's involvement there. But if we don't make that choice, as I tell clients, somebody wearing a black robe, meaning a judge and the state through their processes, and they try to place the kids where they're going to be safe and where they're going to thrive, but their options are often limited, and they've got a lot of competing interests that come forward. They try to place them with family if there's appropriate family, but they're making that decision.
Right, and it's not an immediate decision either. It takes time. Anytime you're involved in the court, it takes a lot of time. So
and the state's trying to do they've got to do background checks. So we're going to talk about how we go about choosing that. But we've brought up now a couple times this concept guardian. So maybe let's just talk a little bit about what is a guardian and what things should we consider when we're choosing a guardian.
Yeah. So guardian, we talk about who's a guardian. Well, that's the person who's caring for your children, who gets to make the decisions where they go to school, what clothes they wear, what sports they're involved in, all those decisions. And they're essentially stepping in the role of the parents at that point. There's also something called a conservator, and that's somebody that manages the finances, the money. If parents have done their plan ahead, and that's something I think we'll talk about, but if they've done their job, they've protected some money, that's a conservator. Oftentimes it's a different person, but the guardian is somebody who is filling that role of the parent, taking care of them.
Right, and we see, families, mom and dad, husband and wife, they're doing this plan, they're trying to choose who should be that guardian. And it's tough decisions. And honestly, when you were young, I'm an attorney, but it was still a tough decision for your mom and I trying to decide, how do we do that? Because, are the people we want to name, there's multiple people. We were blessed to have a wonderful family, grandparents, aunts, uncles that were all very close to you kids. But there were concerns about, do they have the time? Do they have the resources?
Right.
Their age? Are they able to keep up with young children? They didn't all live in the same place local. And so as we go through, that's a tough choice. And we see families struggling with this.
Yeah.
It's just a hard thing. And how do you help clients with that when you're kind of dealing with it? What are some of the questions that we want them to think about when we're choosing who's going to be the guardian?
I think a lot of times when people come in and they have young children, that's kind of one of the first things on their mind is, who cares for my children if I'm no longer able to? And so they've thought through some options of who's going to be that person. And I think the biggest thing that they've thought through is do they have the same values, and do they have the time to help take care of the children? So that's a big one, right? Is, do we have the same values? I can't advise on that. That's something that you should be thinking through. But something that they haven't really thought through is, where does that guardian reside? Are they local or are they not local? Thinking through, how does this actually play out, right? If the guardian, the person who's going to care for your children, is not local, and let's say they're in another state, something happens to mom and dad get into a car accident, they die. Now the kids, they have to go, the state has to decide and evaluate to say, hey, is this person out of state? Are they a proper fit? Are they, is it safe? So they have to do the analysis, figure that out, evaluate this family. It's not going to be overnight right away. So, right, mom and dad died. They're going to have to probably go into foster care. You're going to have that same issue. And then if you think through as well, right, mom and dad just died, and now they're being shipped off to another state far away. They're being pulled out of their school where they have friends. They're involved in sports, theater, different clubs, groups, and really the community that they've known. And now they're being pulled out of that and put into that family. And maybe that's the best option. It is. But I think that's something they have to be thinking through that they don't often. So deciding, is that person local? Or if they're not local, can we appoint somebody who is local for temporary purposes? Maybe there is a neighbor that you say, hey, I don't want them to care for my children forever, but I think that they would be a good option. So mom and dad died that night. The police come by and say, hey, they're the local guardians. Right away they go, they take care of them until maybe the child finishes school, or maybe they finish the school year, they finish the sports season, and then we coordinate. They've evaluated that other family, maybe the parents in another state, and now we can send them.
Right, and this can be like, wow, I was already overwhelmed trying to choose who's my guardian. Now I've got all these other considerations. And I think that is our job as attorneys. We help our clients walk through this, make the decisions. But you're absolutely right. So if we have a guardian who out of the area, they may be hours away. Well, as long as they're within the state, right? So we practice Kansas and Missouri. Right. So I'll pick on Kansas as we have. So, we're here in the Kansas City area. Something happens to mom and dad, and the guardian lives in, Hayes, Kansas. Mm-hmm. Well, we're hours away coming in. So, the children, that's probably they're going to kind of keep them local. They're trying to keep the kids comfortable and get there. But now let's say that guardian lives in Tennessee. Mm-hmm. The court, even though the parents have named the guardian who they want to be there, the state still has a duty to make sure that the children are safe, as you said, to make sure that's person is appropriate, and that it's in the children's best interest. And there's something called the parental preference doctrine that says, absence a showing of extraordinary circumstances, the choice of the parent is in the best interest of the kids. Parent gets to choose it, so that guardian's going to be there. But what if it comes in, they're not able to because of health issues? Maybe, they've just been convicted of some horrible crime, or, there's something going on. Before the state's going to allow the children to go there, they are going to do a background. And if that is an out-of-state, guardian, they're not letting those kids go back to Tennessee in this scenario, leave the state of Kansas, leave the jurisdiction of the court without the court doing this background check and going through processes, as you said, that makes time. So what I tell clients is, okay, let's think through. We've got this out-of-state guardian because that's the person you think that's best suited, the person or people best suited to raise your children. Maybe that's the client's parents themselves, right? Mm-hmm. So it's the grandparents, or it's an aunt or uncle, or somebody that is a close family. Those are typical scenarios we see, and that's who we would want raising our kids if we can't. But they do live out of state. So one, we want to make sure with the guardians, are they able and willing in this unlikely and horrible event that something happens to the parents, are they willing to come to Kansas and stay here with the children until the court will release them, right? Is that something they're willing to do? And even then, I think having a temporary guardian, as you said, local guardian, that's there on a temporary basis that can go, until that process is all done. So we think that stuff through. But you brought up the other issues, which are, you have to consider the age of your children. It's one thing. I mean, this is a horrible event, right? And sometimes there is just no other option. But the kids are in this situation because something happened to mom and dad, either death or some sort of incapacity, disability that prevents parents from being able to raise their children. Right. Parents have named who the guardian is. It's a horrible event. The kids are going to be taken into protective custody, at least temporarily, till they can be placed with his guardian. So they've been yanked out of the home, maybe middle of the night. They're trying to keep them comfortable. But they're young children, and hopefully we've created a situation where they'll be kept together. But as the kids get older, it becomes harder, right? These kids, they're involved, as you said, in sports, theater, schools. They've got friends. They've got the boyfriend, the girlfriend. They have a job. And now you're yanking them away from that. So these children are already at a disadvantage. They've lost a parent, psychological trauma, and now you're pulling everything they know away from them because you're sending them to another state. And sometimes it's the only option we have. There is no better option. So I tell the clients, your homework is stay alive and well, but when they don't. So those are things we need to think through. And I just want our clients to make informed decisions and to have thought this stuff through a little bit and to evaluating who's right one.
Point.
The other thing, so you want to review it, I think, too, is the children age. Is this still the appropriate people? We talked previously about the importance of reviewing your estate plan on a basis and you're confirming those plan choices. Is this still who we want as guardian, given the age of our children?
Maybe they're not the right fit anymore. Yeah, people move. You got to revisit it all the time.
Yeah. Yep. Are they still able to do it? Is this the best fit for the kids?
Yeah.
So going through that. The other thing that I think is giving the guardians information, direction, right? We want to do that. Yeah. We like to do what we call the family meeting, right? And so if we've got guardians, we want the guardians there. I want the guardians to know you're it, right? If something happens, you're it. We hope you never have to play this role. But if you do, this is what it's going to look like. This is what your role will be. We want them to know about us, certainly, so that we're here to help them through that process. But, we just want to go through and also talk to them about what are expectations, right? Hey, to the extent possible, because now these kids are fitting into another home, and all the duties there. These people have children of their own. There's some positives to that, but there can also be some negatives. Are they spread thin? Can they continue to participate in sports the level they have been when mom and dad were alive? So we think through all those things, but also think about, how about relationships with other family members? People, when they go through divorces, they'll set up parenting plans. So here, we can do a parenting plan, give direction to a guardian to say, hey, these are other important people. Right?
Absolutely.
So, and we kind of help our people through that.
Yeah. So I think just, having that family meeting, pulling those people in, telling them what they need to know and making sure, confirming that they're okay with that, and revisiting that again as often, as frequently as, life changes. And then, giving them direction. Hey, if you can't, my child likes this. Maybe they live out of state, so they are not that engaged and they don't know what's going on in your children's life all the time. So being able to leave them some guidance on, this is how I want them raised. Maybe, if religion's a big deal for you, this is, giving them that direction. And that can be done through a letter, through that family meeting, and just
conversation.
Just communicate.
So one thing we wanted to talk about, Sophia, was also about, what we refer to as bifurcating responsibilities. So you brought up there's the guardian and there's the conservator. So let's maybe transition a little bit and talk about the other duties, because it's not just raising the kids and making sure they're getting proper health care and housing and emotional support and development and all those things that a guardian would do. But let's talk a little bit about what is the role of the conservator and why does a conservator need to be appointed here?
Right. So conservator and guardian, those are very, very similar roles, but not very different at the same time. So guardian is somebody who we talked about is appointed to manage them as a person and be that parent. But a conservator is somebody who is appointed to manage the finances and take care of them, make sure that bills are paid, that they've got enough money for food and all of those expenses that go in with raising a child. So sometimes and it's okay in certain situations to have that one family, the adults, be the guardian and the conservator. But oftentimes, and that's mostly how we see it done too. When people come in, they already have an estate plan or they've thought this through and they said, this is who I want to be guardian. Great. But so it's not as common when we see it be a different person fitting both of those roles, but there's a lot of value in having a conservator be a different person than the guardian. One example I can give is the guardian. They've got the children in the house, they're caring for them, and they may have the best intentions, but the child is 16 and the child is on the swim team, right? And they want the child to get as much practice as possible, so they decide, hey, it's in the best interest of the child to build, I don't know how much pools are, 20,000, 30,000, I don't know. I could be way off. 100,000, that is terrifying. But build a whole pool in the backyard, and they just, again, they may have the best intentions, but really was that the best use of the money? And by having kind of checks and balances, having another person be conservative, I think is important. In addition to that, you are kind of protecting that relationship with the guardian. So as the children age and they become teenagers, and
saying teenagers, we're picking on them, but there's some truth to this.
I mean,
sure.
And they've just gone through a very traumatic situation. The parents died, and so there's a lot of responses when somebody goes through trauma, and sometimes that is attitude and frustration and why has this happened to me, and there may be battles between the guardian and that person. But if the child's saying, hey, mom and dad left me that money and that's my money, and they have a fight with the guardian, and if the guardian's controlling the money, that does put them in that bad situation. Now, if we say, hey, conservator, that's a different person. The guardian can say, I don't control that piece of it. It protects that relationship, I think, between the guardian and the child.
Yeah, no, I'm on your team, kid. Let's go tell that conservator we need the money, because that is something we see play out. And often we pick on the teenagers because when they're young, they're not thinking about this. But we see that, and it can be, as you said, they've been through trauma. They have been damaged to some extent. They've lost their parents. They've been put in. And even in the best of situations, it has an impact. And then they hit these teenage years and they want something, and they know there's money there. And it's the mom and dad left me the money. Who are you to tell me I can't have my money? Right. And it doesn't necessarily mean it will, but it can create conflict between the guardian parent and the child that could have been avoided had we appointed somebody else and created a little bit of a barrier, plus to give that protections, because sometimes best intentions, but we may not be thinking about it like, but the kid's 16 and we're going to spend the money to put an in-ground pool in that's going to last for a lot of years beyond that. Was that the best use of the money? Maybe we just need to go get a pass at the YMCA and pay for some additional swim time. So thinking through those responsibilities, should it be one and the same person or people, and do we have backups to them? And those are the kinds of things that I think attorneys can help people through this decision making. All right, next, and we're going to get into eventually how do we solve this. Before we get there, in addition to caring for them, we brought up this idea of conservatorship, to managing the money, the assets, the property that's left behind. But as often the case with young families, when you're raising children and they're young, the rule seems to be for every dollar that comes into the household, 2 are leaving, right? Children are expensive, but we're relying on the income of the parents often.
Right.
The kids are relying on that future income. Mm-hmm. Well, if the parents are killed or incapacitated, we've lost that future income. There may be other demands. If parents are still living incapacitated, there may be demands on that money for their care. Do we have in place income replacement? Mm-hmm. And we often will do that through insurance, or recommend to our clients, hey, maybe we should look. Usually the parents are still fairly young in this place and hopefully in good health and insurable. But, just buying a life insurance policy for that unfortunate and unlikely event, because as I said, most of us are going to outlive our children's minority. But making sure that we've thought through how are we going to pay for this. All right. Anything more you want to say that before I get into how do we solve all those problems?
I like to solve.
All right, solve. This is Sophia's roll up her sleeve. Definitely task oriented. So we're going to solve problems here. So we've talked about before 2 basic ways we can do an estate plan: will-based plan, trust-based plan.
Right. So
let's start with the will, and we've talked previously about problems with wills have to go through probate. Courts can be involved. Well, if we got a child needed care situation, guess what? Court's already involved to some level there. We talked about through this. But let's talk about what does that look like with a will, and how do we structure that will, and how does that tie back into trust anyhow?
Yeah. So will, right, goes through probate. And if we've got one parent alive and one parent dies, well, we're looking at goes through probate, assets for the deceased parent now go through probate, and typically everything goes to the surviving parent. And
because that's how the wills are typically set up. Everything to my spouse survives me. Okay.
Right.
Because by default, it would not, but okay.
Right. And so, we're stepping back again and kind of bringing up a little problem, but I want to provide a solution as well. Is that, this happens. We have a will, it goes through probate. Everything typically goes to their surviving parent. And what if the surviving parent is younger? Even if they're older, typically they remarry at some point. And so now you've lost a lot of resources and ability to care for the child or leave something to the child, because now you don't have any what we call remarriage protection. So we don't get to provide those remarriage protections. Well, what's remarriage protection? So through a trust, what we can do is say, hey, spouse or new surviving parent, I guess. If you remarry, that's okay, right? And statistically, they're going to remarry. But if you remarry, we want to make sure that what's been left for the children is there and it doesn't go now to this new spouse. So we can build in those protections in the trust that if you remarry, you've got to sign a prenuptial agreement protecting those children so that again, that new spouse doesn't get access to it.
We can. And some of the other issues with wills. So if we left the money to our children in a will, whether it goes in, they're under 18, they can't legally take custody and control and charge that money. So a conservator is going to be appointed. Right. Whether we've chosen that person, we did. Well, if we did some planning, right, with the will, hopefully we've named who the guardian, who the conservator is going to be. The conservator has now been appointed. But if that's all we did, they're in charge until that child reaches age of majority, in which case now that's the kid's money, and they take control. They're in charge. They get to make decisions of what to do with their money. And while they may have great heads on their shoulders, we have to recognize at a minimum they lack life experiences. But again, this is a child that's in this situation because they lost parents, they've suffered trauma. And often we see those kids are slower to mature in some ways. In some ways they mature quicker because of this often. But, it's a lot to throw on an 18-year-old. Here's your money. They make poor decisions.
$1 million. Yeah.
But if we haven't thought this stuff out, that's what happens. So often if we're going to use a will, we're going to say, look, in the event that we were to die, and our children are younger than whatever age you want to name, it doesn't have to be 18, under the age of 30, then and only then create a trust, what we call a testamentary trust, meaning a trust created out of a will. It's done under the supervision of the court, and a trustee is appointed to manage the money for those children. Doesn't mean now we can only manage till their age of 30. It says if they're under 30, created, and we can set forth what those terms are. So we've created this continuing trust for the kids. So I think we want to think through that stuff. How do we set these kids up for success? But that will and those testamentary trusts will really never do for us what we can do if we use the revocable living trust, right? We're big proponents and believers in trust. So maybe talk a little bit, if we can, shift the conversation, and we talk about what does that look like when we're leaving to our children in trust?
Yeah. So, when we leave what we've left over, so our, the life insurance policy, your house, all of your assets, you've left that to your children, but we're not leaving it to them outright. So you die, the trustee now writes a check to them and they go get their $1 million and then they go spend it at age 18. We're preventing that from happening. We're making sure that we get a lot of protection over those assets for the child. So we have that trustee who's appointed and they're managing it for health, education, maintenance, and support purposes for the children. So if they decide they need to go to school, they need to, they're getting married, they need to buy a car, they need whatever it is that they need, I would highly recommend giving the trustee discretion to use the funds for that purpose. But maybe we say that the child doesn't really have enough maturity yet. Or maybe we don't know, right? We're doing this trust and the children are 5 years old, 4 years old. We don't know what they're going to be like on age 30 years old. So, we could say, yeah, sure, trustee, give them everything at age 30. Or we could give the trustee discretion and say the trustee is going to know at that point. The trustee can see, hey, are they mature? Are they of sufficient age and maturity? And that's what we like to do in our trust documents. And so thinking through, what does that look like in 10, 15 years? Well, if the trustee can say, yeah, I think at this point, the child is of sufficient age and maturity to receive, to be the trustee of their own share, then they get that. What does the trust provide? That a beneficiary designation or going through probate doesn't provide. Well, a big thing it provides is asset protection, and we're big proponents of the trust because of being able to provide asset protection. Well, what does that even mean? And if you want to just explain that a little bit more,
Well, I think it goes back to as we tell everybody, think of a trust as being like a safe, right? We create a safe. Whether that safe was created out of a will, what we call the testamentary trust, may comes in existence after the death of the will maker, or we created the trust during our lifetime, the living trust. It was created while we're alive and says, hey, upon our death, then get it to the kids. The assets that are in that trust, if we've structured the trust correctly, they're divorce protected, they're bankruptcy protected, they're creditor protected. We get to decide who has the key to the safe. And just because the kid turned 18 doesn't mean they get the key, or because they hit some magical age, they don't necessarily have to get the key. You get to decide that when you create the trust. But what I see, and I would say this is the vast, vast majority of the time, people will bring me their estate plan. I'm glad they've thought this stuff through. They've named who the guardian's going to be. They've created trust for the kids. They've thought through how we're going to get money for the kids. It's in these trusts. But then they set up these trusts in a very, what I believe to be kind of an arbitrary way. As you said, the kids may be 4, 5, 6, 8 years old. We've created this estate plan. We've created the trust. And we say, okay, it's in trust for the children's health, education, maintenance, and support at trustee's discretion. But when the child reaches age 25, they have a right to receive a 1/3 withdrawal, another third at age 30, and then take the final distribution at age 35.
That's the most common way I see it.
Most common. Yeah. And there may be, the ages may differ a little bit. It may be age 25 or completion of college, whichever occurs first, or it might be in 4 distributions instead of breaking a third, it's 25%. But it's all based on age. And what I tell clients is, that's not necessarily wrong, but let's think this through. Your kid's 5.
Right.
I don't have the crystal ball, nor do you, to know what your children are going to be like at age 25 or 30. I don't know. I mean, they've been through trauma. They've lost their parent. And depending on how old they were when that happened, we may have some trauma here. They may, have some issues going they're dealing with. But even in the best of scenarios, we don't have that. Just because someone reached 25, I don't know, do they have an addiction issue? Right. Drugs, alcohol. Maybe they're just really bad with money, or they're looking, they've had so much loss in their life. They're looking to buy something. So at 25, they want that money so they can go buy their boyfriend the brand new truck. And that relationship ends 6 months later, and there goes the truck because it's in boyfriend's name. And we've seen this stuff happen. And we put an age limit that was so arbitrary because the kid was 5. I don't know what they're going to be like at 25. So what I talk to clients about is I say, look, rather than an age, which again, if you want to do it this way, it's your plan, we can do that. But what if we said that the trustee, this person we've appointed to manage it with them while they're young, continues to manage it for the children. So it's the children's money. They're just helping manage it for that child's health, education, maintenance, and support at trustee's discretion. And trustee, because that trustee, and we've put them in the position we would be as parents if we wanted to get money to the kids. We said, trustee, when you believe the child is of sufficient age and maturity that they can take the key themselves, that you think they're going to be good with the money, give them the key. Because as a parent, that's what I'd have done if I had money I want to give to my kids. If I believe they could handle it, I just give it to them. I don't need to manage it for them anymore. So you're putting that person in that position when they believe they're of sufficient age and maturity. And just because somebody hits some magical age doesn't mean they have it. They might. Some kids may get there sooner than others, right? One kid may get there at 25. One kid may never get there, right? So we have somebody who's managing the money for the benefit of the child, but we certainly don't want to give the money to them if it's just going to turn around and be used on drugs or alcohol or squandered away. But again, each parent, each client gets to make these decisions for their kids, but they got to choose to do so. They got to get the plan in place. If they don't plan, then the court's going to make that decision.
Yep.
And when we do plan, we're often not thinking this stuff through fully, and we're not making fully informed decisions about how we get the money.
Right.
All right. The last thing, and you have talked about this when you and I were talking in advance of the program here starting today. We talked about having, when do we divide? And I don't want to go, too deep, because we could go on for a whole hour just on, pooled trust versus, dividing them up a little bit. But as we're paying for expenses of children, there can be some value to thinking through of when do we divide this up. So if you would, let's just maybe talk about that if we can. So
our goal when we do estate planning is to be comprehensive, but keep it simple. And we want to keep it simple. And so there are so many options. And one of my paralegals laughs at me a little bit and says, "Oh, you always say that there's so many options." And I love options, but I don't need to present every single one of those options to our clients because it's overwhelming and these decisions to make. But sometimes, there are these options and they're good options for certain people. So something that we can do is we call it a common pot trust. But if you think of it, it's a common pot, right? While they're still young and they've got different expenses, they're all in grade school. Do we want to divide it up a third, a third, a third? I've got 3 children, third, a third, a third. Maybe it's not fair. Maybe the oldest child has already been put through a majority of their schooling, and when mom and dad die, and so now they get a third right away and they're going to college and they get to do that. But the other third, to the youngest child, they haven't even been put through schooling yet. So they've got to use their third to go through schooling. You got to decide, is that fair? There's a lot more things we can do to make it a little bit more fair. We can make it a little bit more complex if we want to, but we want to keep it as simple as possible. And you had a really good point earlier about, if you leave it in a common pot trust, it can invest and grow as well. And so is it fair? I don't know. We've got to talk that through. What's the plan? What's the goal? What do we want to do with the money? How much money is there going to be? Do you have life insurance? All those things we got to look at. It's a very holistic approach when planning for young children.
So hopefully we have not overwhelmed everybody, because as we said, this is one of the hardest decisions we make as a parent. And because of that, we put this off and we don't do the planning because we're frozen by having to make some very, very tough decisions. Right. But what I would encourage people to do is let's start down this process. Let's make that. And again, we can always adjust the plan. I like to use the analogy I tell clients, it's wet cement. This is not formed. As long as you stay alive and competent, we can change this a plan. And we should evaluate it on a regular basis. I find once a year is good. Now, if something happens to the guardian or there's change in that, we tell the clients, don't wait till the next annual review to tell us about this stuff. Get in here. Let's talk about this. We're always reviewing our plan choices, typically on an annual basis, and reviewing who's the guardian, what does this look like, and really thinking it through how it's going to work if this were to come into play. And that's where we think people go wrong. And so much of the planning, we think that they don't really think through how does it work we get there. And unfortunately, you and I are the belief that a lot of attorneys, I think, aren't really helping their clients think through this stuff. So we want to help our clients think through what does it look like. Don't get frozen with indecision. Work with professionals that are going to help guide you through this. Make the best decision you have with the evidence and facts that are before you. We can adjust those decisions as we go on.
But make a decision.
Make a decision.
Get something in place, because if something does happen, and it's not very likely that it will, but if something does happen, you've made the decision. Like you said, not the judge.
Right. So, if somebody finds themselves, right? So if you find yourself in this position and you haven't made it, get this done. Get a plan in place. Think through, where do these people live? Do we need temporary guardians? Somebody you can fill in will help you do the process. So I would just encourage you to get a plan in place. All right. So that's about all of our time here today. Any parting comments you have for anybody as we wrap up here? All right. So I just would encourage you listeners, if you find this information to be relevant and helpful, subscribe, share. You will find us on Apple Podcasts, Spotify, and YouTube. You can also go to our website, stocktonlaw.com, and you'll find the various platforms as well as our podcast there. Again, this podcast is designed to bring useful and relevant information to you to help you make the choices for you and your loved ones that make the most sense and to do some good estate planning. So with that, thank you for tuning in, and we will see you on our next episode.
The information provided in this podcast is for general informational purposes only and does not constitute legal advice. Listening to this podcast does not create an attorney-client relationship. Laws vary by state, and this podcast focuses on estate planning and elder law in Kansas and Missouri. If you are located in Kansas or Missouri and require legal advice, please contact our office. Otherwise, consult a qualified attorney licensed in your jurisdiction.